This is English shorthand dictation number 262 and the dictation speed is 140 words per minute. Ready? Start. The establishment of an educational institution is always an auspicious occasion. I am glad that I was invited to participate in this foundation stone laying ceremony. At this forum, it would be most appropriate for me to share some thoughts on the state of legal education in our country and the direction it should take. All of you are well aware that the legal profession itself is undergoing massive changes. The young law graduates now have a range of opportunities to choose from. While joining the chamber of a senior practitioner is the most commonly adopted route, opportunities have also emerged in commercial practice as well as research and voluntary sector work. With increasing opportunities to study and work in foreign countries, qualified lawyers can also look forward to careers in international institutions and multinational corporations. However, it is also true that these diverse and often lucrative opportunities are only available to graduates from a few top institutions. Most of our law colleges and departments are perennially cash-strapped and struggle to retain qualified and motivated law teachers. Some colleges also function in a very politicized environment, where serious academic pursuits often take a back seat. However, all of these problems can be effectively solved with some initiatives and a sense of commitment. In this regard, we must recognize the role of our law schools in not only preparing individuals for the bar and judiciary, but also as the breeding grounds for democratic values and meaningful social engagement. Most of the leading lights of our freedom movement were from a legal background, and in today's times, there is a compelling need for lawyers to play a transformational role in our society. Traditionally, legal education has stressed on the development of skills needed to conduct meticulous research, speak effectively, and respond to arguments. While these are essential traits of a good lawyer, there is also a need to imbibe values such as tolerance and empathy. Building a successful legal practice also requires effective interaction with clients. Very often, advocates tend to impose solutions on clients rather than listening to them and suggesting the best course of action. In some instances, clients are encouraged to engage in unnecessary litigation without exploring alternatives such as mediation and negotiated settlements. Even in the courtroom, both lawyers and judges often get entangled in excessive argumentation and technicalities, while losing sight of the real interests of the litigants. We are all encouraged to think like a lawyer and win arguments rather than coming up with mutually beneficial solutions. In many ways, this predisposition towards a combative style of functioning also goes back to the structure of our education system. In our present system, young law students are always competing against each other to do well in academics and eventually secure good job opportunities. However, this spirit of competition should also be channeled in creative and innovative ways which give them better preparation for their careers. Our law schools must be conceived of as spaces that encourage rational and critical inquiry into socio-economic realities. Meaningful practical experience through participation in legal literacy programs, involvement with NGOs, and regular visits to institutions such as courts, police stations, and prisons, among others, will give students a chance to observe the law in action as opposed to the law in the books. Law students can actually play a vital role in spreading legal awareness among the disadvantaged sections. For many communities of the urban poor and those in remote villages, there is little awareness of even the most basic rights given under our family laws, property laws, and criminal laws. By disseminating what they learn through legal services programs, law students can actually be the agents of real social change. Furthermore, the interactions between students from well-to-do backgrounds and the disadvantaged sections can be an effective method to bridge social divisions based on caste, class, religion, and gender, among others. Legal education is not just a means for personal advancement, it can also act as a stimulus for deepening democratic values such as tolerance of diversity and the willingness to resolve disagreements through constructive and informed dialogue. I am confident that if we are able to promote a meaningful understanding of our constitutional values, it can be the basis of a more equitable and caring society in the years to come. Building a law-abiding society is, of course, a very gradual and ambitious process, but we should not give the generations to come a chance to fault us for not having tried. I have been asked to say a few words on the desirability of speedy justice. There is no doubt that this is an important part of judicial administration. In many cases, the undue delay in disposal is a consequence of hurdles placed in the procedural steps involved in litigation. In the course of a legal proceeding, there is a likelihood of delay at various stages, from the service of notice upon the parties, the framing of issues, submission of pleadings, examination of witnesses, production of documents, and the counsel's arguments. If a party anticipates an adverse result, there is a tendency on part of litigants or practitioners to place obstacles in these proceedings. The logical response to this endemic problem is that judges need to be more proactive in managing the flow of proceedings before them. Attempts to delay the proceedings should be treated firmly, but it must also be kept in mind that the desire to improve procedural efficiency should not compromise the quality of justice being delivered. As inheritors of the common law tradition, we are bound to follow the principles of natural justice. As per the principles of natural justice, no man should be a judge in his own cause. No person should be condemned unheard, and every order should be a reasoned order. Even though the judges are the main actors in the justice delivery system, their efficiency is closely related to the behavior of advocates, litigants, investigating agencies, and witnesses, among others. While public scrutiny is rightly being directed towards the performance and accountability of judges, there is also a need to examine the responsibilities of all the other participants in the judicial system. In particular, there is an urgent need to tackle the institution of frivolous claims and the giving of false evidence. Judges can perform their fact-finding and adjudicatory roles in a satisfactory manner only if they receive the cooperation of all the stakeholders. In this sense, the judicial function is as much a collective enterprise as the other wings of government. A meaningful shift will only occur if attitudes change among the bar. Ultimately, it is the responsibility of legal practitioners to advise their clients on the suitability of resorting to litigation. For resolving many categories of disputes, adversarial courtroom litigation is not appropriate, since disputes can be amicably resolved at the pre-trial stage. With the objective of promoting awareness about these methods, full-time mediation centers have been established in the various high courts as well as some of the district courts. Their function is to not only provide mediation services but also to impart training about the same. I must also comment on the importance of legal aid programs, especially those which seek to impart legal literacy in remote and backward areas. We must acknowledge that access to legal education is still confined to a privileged few, and that the existing pool of judges and lawyers is not adequate to bring about the changes that we desire. In recognition of this fact, a committee headed by a sitting Supreme Court judge has been recently appointed to oversee the training of motivated young individuals as paralegals, who can then expand the reach of the legal aid programs. We are also in the process of designing a project dedicated to the improvement of access to justice in the northeastern region of the country. I hope that improved awareness and access to legal remedies will help in mitigating the socio-political conflicts in troubled areas. Efforts are also being made to incorporate information technology based solutions in order to strengthen the judicial system. Under the e-courts project, most judicial officers in the country have been provided with computers, printers, and access to legal databases. Steps are also being taken to digitize precedents as well as the permanent records of courts at all levels. At present, the daily cause lists, orders, and judgments of the Supreme Court and the respective high courts are freely available online through the Judgment Information System.